Today we're going to cover traditional marriage and alternatives. So this chapter talks about legal issues prior to marriage, any actions you could bring if there's a broken engagement, what happens to the engagement ring, or any wedding gifts that you were sent. We'll also talk about the introduction to marriage, ceremonial marriage, anything but marriage, which includes civil unions and domestic partnerships, the Defense of Marriage Act, also known as DOMA. We'll talk about same-sex marriage, adult adoption, covenant marriage, common law marriage, putative marriage, marriage by estoppel, de facto marriage, and the struggle to find a remedy. So in anticipation of getting married, we all hear about different engagement stories, the proposal, especially more recently with social media, proposals have become more public. Those stories used to take place in private, but now you may have many of your friends or you yourself have hired photographers or had gone through elaborate stories or elaborate planning just in anticipation for the proposal itself. Unfortunately, over 100,000 engagements are broken every year. And it's not a cheap experience when that happens. So on average, you could spend anywhere from $30,000 to $100,000, depending on where you live, how many guests you invite, what kind of person you are, if you really value having that one special night in your life. Now, what happens if you've paid all these vendors and right before your wedding night, one of you or both of you decide to break the engagement? What happens to all those vendors that have to be paid or have been paid? What happens then? In a minority of states, one person can sue another for the breach of promise to marry. These lawsuits are also called heart bomb actions because they're based in the loss of love and relationship or a broken heart. California is not one of those states that allows heart bomb actions of breaching a promise to marry. California, among other states that do not acknowledge these actions, simply don't want to get involved in the intimate decision, personal, intense, and possibly bitter decision to break off an engagement in anticipation of marriage. Also, they believe that people should be able to correct their mistakes outside of a courtroom. So whatever personal issues they're having, they don't need to bring that into the courtroom to solve it. Also, allowing breach of promise to marry actions or heart bomb actions could encourage gold diggers and blackmailers to sue former partners or ex-fiancés out of bitterness or spite. So there are many reasons why states, including California, do not allow these heart bomb actions. However, for those that do, the main remedy available is compensatory damages. So like I mentioned before, this is the money that would restore an injured party to his or her position prior to the injury of loss. So compensatory damages are payments to cover the hall or the wedding venue, the DJ, any catering, or the wedding cake. They're meant to compensate for those damages. Damages for humiliation and mental anguish are also allowed. So what if your 300 guests have already bought their tickets to fly to this destination wedding? They've already spent money on outfits, they've already bought gifts. That's humiliating, can be humiliating. So damages are allowed for that as well. Now, the remedy of specific performance, which would basically force the parties to perform the contract as originally promised, which is here to get married, is not enforceable because courts would not want to force a marriage that at least one of the parties no longer wants. Expectation damages are no longer allowed as well. What about a fraud action that's based on a breach of promise to marry? California says no. because it stems from the breach of promise to marry or the heart bomb action at the core. Some states differ on this. What exactly is a tort action of fraud? A tort action of fraud is sometimes known as deceit or misrepresentation. There must be a false statement of present fact by the defendant. The defendant must know that it is false, and the defendant must intend that the plaintiff rely upon that statement, this element known as scienter, which is the intent to deceive. The plaintiff must rely on the statement of the defendant and be reasonable in so relying. Finally, the plaintiff must suffer harm due to the reliance. So an example of how a fraud cause of action might arise out of a broken engagement. Don tells Phyllis that he wants to marry her. At the time he makes this statement of fact, it is false because Don has never wanted to marry Phyllis. He knows he's lying. Don's goal, his intention, is to obtain a loan of $25,000 from her. He knows that without a marriage proposal, she will refuse. Phyllis, however, believes that Don wants to marry her, and she lends him the money in reliance on his promise of marriage. Soon thereafter, she learns that he never wanted to marry her and that he has spent the money she lent him. Her reliance on his promise has led to the harm of losing $25,000. Here we could see that each of the elements of the fraud tort is met. So there's a false statement of present fact by the defendant, which is that he wants to marry her. The defendant must know that it's false. At the time he makes this statement of fact, he knows it's false because he never really wanted to marry her. The defendant must intend that the plaintiff rely upon that statement or the element of scienter. His true intention was to get a loan of $25,000 out of her. He knows that without asking her to marry him first, she would refuse the loan. So there's the intent or the scienter element. The plaintiff must then rely on the statement of the defendant and be reasonable in so relying. She agrees at this point, Phyllis agrees to lend him the $25,000 because he's asked her to marry him. And she knows that they'll be a married couple. She feels comfortable lending him $25,000. Now, you'll notice as part of this element is that she not only relies on the statement of the defendant, but she has to be reasonable in relying So here you could talk about the amount of money that's being lent. $25,000 could be considered a reasonable amount of money between two parties who are to be married. Now, what if the amount was $3 million? Would she be reasonable in relying upon his statement of getting married to loan him $3 million? At that point, courts would probably raise an eyebrow or two. So that element does look at the reasonableness of the reliance. And then finally, the plaintiff must suffer harm due to the reliance. Here, she did suffer the loss of $25,000 in reliance of his initial proposal to marry him. So that's marry her. So that's an example of a fraudulent action that's based out of a breach of promise to marry. So again, California does not allow heart bomb actions, and stemming from that does not allow for fraudulent actions based on the breach of promise to marry. What about the tort of intentional infliction of emotional distress? A plaintiff must convince a court that the heart bomb statute does not bar this action as well. So similar to fraud, it most likely stems from the breach of the promise to marry. If they're able to overcome that hurdle, they then have to prove that they were a victim of particularly shocking conduct by the defendant. So, for example, a man knows that his fiancée is emotionally unstable because she is a former mental patient. He proposes marriage for the sole purpose of humiliating her by changing his mind just after she makes elaborate, public, and expensive wedding plans. A state might conclude that this is sufficiently outrageous and shocking conduct. So the fact that he did this to publicly humiliate her could rise to an action of intentional infliction of emotional distress, or would be considered shocking behavior. Now your everyday run-of-the-mill engagement breakup of couples saying, I just don't think we're compatible as a couple. I think we're making a mistake. Just your everyday breakup would not rise to the level of shocking conduct that's necessary to prove intentional infliction of emotional distress. So this is all just leading up to the marriage itself. So these are examples of actions some states, some individuals are allowed to bring in, some states, not California, based on the breach of promise to marry. Now, what about the engagement ring? So in general, gifts are the voluntary delivery of something with the present intent to transfer title and control for which no payment or consideration is made. So consideration is something of value that's exchanged, okay? The two parties in a gift exchange include the person making the gift, who's known as the donor, and the person receiving it, who is the donee. What about wedding gifts, however? Would these be considered irrevocable gifts? Well, generally, guests would give a couple a wedding gift in anticipation or on the condition that the couple get married. So let's say I have my registry on Amazon. I'm set to be married in Valentine's Day of this year. All of my guests are wonderful people. They send me everything I ask for on my Amazon registry. Well, on February 13th, I decide to call off the engagement, and the wedding is canceled. What then happens to all of those gifts from my Amazon registry? Do I get to keep it or no? It's arguable that these are wedding gifts that are conditional upon the occurrence of the wedding. So since it's no longer happening, these would be considered conditional and revocable gifts that could be returned back to the donor. Now, on the same token, what about engagement rings? Engagement rings must be returned except in the few states where the ring does not have to be returned to the person who broke the engagement without justification. This person is not entitled to have the ring returned to him or her. Now, what does California say about this? California Civil Code Section 1519 says that where either party to a contemplated marriage in the state makes a gift of money or property, aka engagement ring, to the other on the basis or assumption that the marriage will take place, in the event that the donee refuses to enter into the marriage as contemplated or that it is given up by mutual consent, the donor may recover such gift or such part of its value as may, under all the circumstances of the case, be found by a court or jury to be just. So let's say I'm making the proposal, and as part of my proposal, I offer an engagement ring. Now I'm the donor offering the engagement ring. Now the donee accepts the ring, but then later changes their mind. They say, you know what, Janelle, I changed my mind. I don't want to marry you. Since they refuse to enter into the marriage, I am able to recover my engagement ring that I gave that person. Now, if we both also agreed, if it's we refuse to enter the marriage by mutual consent, then I also can recover the engagement ring. Now, what about if I decide to break off the engagement? Would I still be able to recover the gift or the engagement ring? This may be up to the court or the jury to decide if it's just or not. What are the circumstances surrounding my breaking off the marriage? So this is what California says about that. And I personally never thought about what happens to an engagement ring. I have one, but this was just something that never really crossed my mind. But we do have it written out in civil code, so it's just another token of knowledge to keep in your back pocket, especially if you're contemplating buying a really expensive engagement ring or a family heirloom, just to know what happens in case the engagement is broken off. So we're moving on to restraints of marriage. These generally pop up in trusts and wills. They could also be written out in contracts. So general restraints, these are contracts that impose a total or a near total prohibition on marriage. These are unenforceable. So for example, in exchange for a large sum of money to be given to her by her father, Mary agrees to never marry. Here is a general restraint because Mary's father is asking her to never marry. That would not be enforceable. It's a total prohibition on marriage. Now, what would be a more reasonable limitation? This is a contract that imposes a reasonable limitation on one's right to marry, and these are enforceable. So some examples of these, first, a reasonable limitation on marriage is one that is a partial rather than a general prohibition, so it doesn't prohibit getting married outright, and it serves what the court feels as a useful purpose. Interesting. Useful purpose. And 3, it's not otherwise illegal. So some examples of reasonable limitations. Jim enters a contract in which he promises that he will never marry a woman who is not of his religious faith. Mary enters a contract in which she promises to never marry anyone who has a criminal record. Jill enters a contract in which she promises that she will not marry before she turns 18, and that if she decides to marry between the ages of 18 and 21, she will obtain the permission of her parents. Final example, Linda enters a contract in which she promises that she will not marry until she completes her college education. So do you see the common thread amongst these examples? First, all of these restraints are partial. They don't totally prohibit marriage or come near such a total prohibition. All of these restraints are arguably to serve a useful purpose. So, arguably, the court will have to decide whether or not the purpose is useful or not ultimately. Here, they try to protect a person or to preserve a valuable tradition or culture. In most states, restraints on marriage with the reasonable limitation will be enforceable. Along with that, we're moving on to the anti-nepotism policy. Nepotism is favoritism shown to relatives, and anti-nepotism policies forbid employees to be married to each other. Such policies are enforceable. So they're not saying that you can't be married to anybody who's your coworker. If you look into California labor laws, they will enforce anti-nepotism policies that, for example, prohibit supervisors from having intimate relationships or being married to their subordinate. So it really depends on the organization, whether it's public or private. But overall, these anti-nepotism policies that forbid employees to be married to each other in those types of subordinate positions can be enforceable and are enforceable. Now, can you think of the reason why they're reasonable and enforceable? Most courts will consider them to be reasonable and enforceable because they help avoid spousal quarrels in the workplace. They avoid the appearance of favoritism if a spouse has supervisory authority over his or her spouse, and cuts down on scheduling problems when, for example, the spouses seek the same vacation dates. So what they're really trying to do is to prevent potential conflicts, either between the married parties and also amongst other employees who could see favoritism or could be subject to their quarreling. It's worth looking into if you don't already know your employer's handbook and what their anti-nepotism policy is, and if they have one. Okay, we're now segueing into marriage. So there's two definitions. First is the legal union of a man and woman as spouses with designated rights and obligations to each other. The better definition that applies today is the legal union of two persons as spouses with designated rights and obligations to each other. It's been a long and contentious road between the two definitions, but as you'll see and as you've read, based on the evolution of the same-sex rights, right to marry, we are settling with the second definition, in which marriage is the legal union of two persons as spouses with designated rights and obligations to each other. As we learned during the first week of family law and the introduction to family law, the right to marry is a fundamental right. A fundamental right is a right that is specifically guaranteed in the U.S. Constitution, is implicit in the concept of ordered liberty, or is deeply rooted in the nation's history and tradition. Marriage falls into this third category in that it is a right that is deeply rooted in the nation's history and tradition. We're going to talk about two cases that have shaped the discussion on the right to marry and marriage and intimate conduct as a fundamental right. So Zablocki versus Redhill held that only reasonable regulations that do not significantly interfere with decisions to enter into the marital relationship may legitimately be imposed. There, they found that a state could not require an unmarried person to prove compliance with current child support obligations before being allowed to obtain a marriage license. So in that case, a man wasn't allowed to marry because they found that he was late on his child support obligations. The court found that this was not a reasonable regulation because it didn't have a legitimate purpose as it relates to getting married. Loving versus Virginia held that any laws against mixed-race marriages or miscegenation impermissibly burdens the fundamental right to marry and is a denial of equal protection of the laws. Both the Zablocki and Loving cases underscore marriage as a fundamental right. And as the U.S. Supreme Court stated, the freedom to marry has long been recognized as one of the vital personal rights essential to the orderly pursuit of happiness by free men. There are two types of marriages. A ceremonial marriage, in which one is it's entered by comporting with the statutory requirements of that state, and common law marriage. It's a marriage that's entered without a license or without a traditional ceremony by persons who agree to marry, live together as husband and wife, and hold themselves out as married to the public, to their friends and family, to the world at large. Ceremonial marriages require technical or procedural requirements, along with essential requirements that we're going to go over next week. So some of the main procedural requirements that are required in California including are a marriage license, an authorized officiant, witnesses, a marriage declaration. We take each other as the statement where you agree to be husband and wife or spouse and spouse, a waiting period between your marriage license, when you get your marriage license, and when you actually perform your ceremonial marriage, recordation with your city or county clerk, what happens when you violate one of these technical or procedural requirements? So let's say I actually did happen to get married in San Francisco City Hall. Let's say I didn't have two witnesses. I only had one. Well, what would really happen is that they wouldn't allow us to move forward with the marriage, the ceremony. But let's just say they did. Let's say I failed to comply with the procedural requirement of two witnesses in California. In general, a violation of this requirement is not grounds for annulment. Violating essential requirements, however, are grounds for annulment. So we're going to talk about that next week. These essential requirements could be, for example, being of minimum age to marry, or let's say I was still married to somebody else. These would be essential requirements that could be grounds for annulment. So again, violating technical or procedural requirements are not grounds for annulment, but violating essential requirements, which we'll go over next week, are grounds for annulment. What about proxy marriages? Do both parties need to be there to actually get married? What about the officiant? Do they need to be there to marry you? A ceremonial marriage in which agents or stand-ins take the place of one or more of the prospective spouses because of their absence at the ceremony. Marriage by proxy is generally not allowed in California, so I can't go to San Francisco City Hall and say my husband to be is not here because he's working right now, but here's a proxy who's going to stand in for him. That's not allowed. Family Code Section 420, subsection A, requires the two parties, the marriage officiant and witness, if applicable, be physically present together in the same location for the marriage to be performed. Now, California Family Code 420 Section B does allow a member of the armed forces of the United States who is stationed overseas and serving in a conflict or a war and is unable to appear for licensure and solemnization of the marriage to enter into a marriage by the appearance of an attorney in fact, commissioned and empowered in writing for that purpose through a power of attorney. So it's a very specific statute that does allow proxy marriage in this very specific circumstance involving an armed forces soon-to-be spouse. And you would have to submit or file a power of attorney. There's a lot of forms involved. If you're interested in that, I do believe I added that in the link. So this is how California deals with proxy marriages. What about everything else that's not marriage, or anything but marriage, also known as ABM or EBM, everything but marriage? We typically hear of these things known as civil unions and domestic partnerships. So civil unions are a same-sex legal relationship in which the individuals in the relationship have some or all of the same state benefits and responsibilities as individuals in a marriage. By contrast, domestic partnerships are a same-sex or opposite-sex legal relationship of unmarried individuals who are emotionally and financially interdependent and who have some or all of the same state benefits and responsibilities as individuals in a marriage. So as you read through the long and winding, contentious road to legalizing same-sex marriage in all 50 states, which is today, some states have gone a lot back and forth, legalizing same-sex marriage, repealing that right through propositions, like we did Proposition 8. To combat that, states enacted anything but marriage, civil union and or domestic partnerships, kind of as a way to quell both sides, to appease both sides, to provide alternative roads that'll eventually, hopefully, would lead to the legalization of same-sex marriage. California specifically has domestic partnerships, which is a same-sex legal relationship. Only if one of the individuals is 62 years or older is it allowed to be an opposite sex relationship of unmarried individuals who are emotionally and financially interdependent. So the reason California allowed for domestic partnerships was to allow same-sex couples to receive the benefits that the legal benefits that many married couples enjoy, but that they were prohibited from doing so. So many of these benefits include, but are not limited to, allowing their partner to be a covered person on their health insurance policy, receiving workers' compensation benefits when their partner is injured on the job, being able to bring a lawsuit for the wrongful death of your partner, being allowed to visit a partner in a hospital and to make medical decisions for an incapacitated partner, filing joint state tax returns, and receiving a portion of the estate of a partner who dies in a state or without a valid will. So there are many benefits that those in domestic partnerships could enjoy without being able to marry. Now, as part of your discussion for the week, I ask you what your views are on domestic partnerships. Do we need both now that same-sex marriage is legal? With the pros and cons. So we'll dive a little bit deeper into that. But it is important to know that California does allow domestic partnerships and has for some time. Okay, so now we're moving on to the federal statute that I'm sure you've heard of in the news, DOMA, the Defense of Marriage Act. Basically, it's a federal statute that says one state is not required to give full faith and credit to a same-sex marriage entered into another state. For federal purposes, only opposite sex marriage is recognized. So first of all, let me just underscore that DOMA is really looking at the federal benefits. So they're talking about um, so backtracking to domestic partnerships, they would domestic partnerships in California allow same-sex couples to file joint state tax returns. Under DOMA, while it was constitutional, it prevented so that while they may in California, let's say they were allowed to file same-sex as a same-sex couple in a domestic partnership, they were able to file a joint tax return in California. Under DOMA, they would not be able to file a joint tax return, a joint federal tax return. So they'll have a joint state tax return, but they'd have to file a separate federal state tax return. The DOMA is really looking at, for example, federal tax returns, any federal benefits such as Social Security, federal income tax, immigration. This is what DOMA was really trying to control. Also, and mainly, they tried to overrule the full faith and credit requirement that is delineated in the U.S. Constitution, where a state has to recognize and give full faith and credit to others' official decisions. So it all started in Hawaii, where they were potentially going to be the very first state in 1993 to recognize same-sex marriages. All the other 49 states started to freak out and worry that because of the Full Faith and Credit Act, they would have to honor any same-sex marriage that took place in Hawaii, and if that couple came to live in their state. So as a response, the Defense of Marriage Act was enacted, which basically kind of tried to overrule the Full Faith and Credit Act credit clause of the Constitution, stating that one state is not required to give full faith and credit to a same-sex marriage entered into another state. So if a state did want to recognize another state's same-sex marriage, it still could, but DOMA just said that it wasn't required. It also didn't say that same-sex marriages are illegal. It simply stated that just because one state recognizes it, another state is not forced to do so. Mini DOMAs. So state statutes followed suit. So many states took after DOMA, and they established statutes that stated that there was a strong public policy of the state to not recognize any same-sex marriage that might be validly entered into another state. Okay, perfect. So this is a perfect segue into the conflict of laws. So what happens if a couple is married in California and then they move to Texas? And they have issues there concerning the marriage, the breakdown of the marriage, anything related to their marriage. How will a court interpret, first of all, the legality of their marriage? Let's say there is a same-sex couple and they move to a state where same-sex marriages are not recognized. The validity of a marriage is determined by the law of the state in which the marriage was entered or contracted. Another state will recognize that marriage unless to do so would violate a strong public policy of the state asked to recognize it. So this is the conflict of laws and the validity of marriage. So they would look at where the marriage was entered into or contracted, and the state that they ended up moving to would have to recognize that marriage unless to do so would violate a strong public policy. So that's why these mini DOMAs were enacted at the state level by statute to say that there is a strong public policy in not recognizing any same-sex marriage that might be validly entered in another state. So you could see this as kind of an offense mechanism, actually, in anticipation of any same-sex marriage couples who were to land in their state. They would point out to this statute, their mini DOMA, that we have a strong public policy to not recognize your state, kind of, and that's how they would deal with any conflict of laws regarding a validity of marriage. So it's important to note that as of today, the Defense of Marriage Act was deemed unconstitutional. This was ruled by the U.S. Supreme Court in June of 2013. Now, since the unconstitutionality of DOMA, there's been a host of cases that I hope you read through in your book. One of them that I mentioned as part of this week's discussion thread is Perry versus Schwarzenegger, which takes place in California. The latest case that has kind of been the landmark civil rights case dealing with same-sex marriage generally took place in 2015. Obergefell versus Hodges. The U.S. Supreme Court ruled that a ban on same-sex marriage violates the U.S. Constitution under both the Due Process Clause and the Equal Protection Clause of the 14th Amendment. So we could spend an entire lecture just talking about the ruling of that case and all the cases leading up to it. But it's important to know that now same-sex marriage is legal in all 50 states. DOMA is unconstitutional. And bans on same-sex marriages are unconstitutional, and they violate the U.S. Constitution under both the Due Process Clause and the Equal Protection Clause of the 14th Amendment. So that's why I said from the two definitions earlier of marriage, today we have made it all the way to definition number 2, where the legal union of two persons is spouses with designated rights and obligations to each other. It's no longer the legal union of just a man and a woman. Okay. All right. So we're not done. So these slides cover substantive due process and equal protections of the law. So remember that the right to marry is a fundamental right, and it triggers strict scrutiny. So by triggering strict scrutiny, the state has to justify the law by showing that it is narrowly tailored to serve a compelling state interest. If it cannot do so, the law is struck down as a violation of SDP, which was found in Obergefell versus Hodges, and why any same-sex ban is considered unconstitutional. Let's see. Okay. So Lawrence v. Texas, we talked about that last class. The court struck down a Texas statute that made it a crime for consenting adults to engage in private or same-sex intimacy. While the majority did not rule that the ban on same-sex marriage was unconstitutional, the dissent argued that the court's ruling did call into question the constitutionality of the ban. So Lawrence v. Texas was alluded to numerous times leading up to Obergefell. And what it really did was recognize the intimate conduct of between two individuals as a liberty interest to be protected. So Lawrence v. Texas was very important for that purpose. And did call into question the constitutionality of the same-sex ban overall. Because why stop there? Why stop at intimate conduct? If we're not allowed to meddle into the intimate conduct or infringing on the liberty interest rights of two consenting adult individuals, why is it okay to ban same-sex marriage? So Lawrence v. Texas was one of the major landmark cases to lead the road or pave the road leading up to Obergefell. Similarly, under equal protections of the law, Obergefell in the U.S. Supreme Court held that the same-sex marriage bans triggered strict scrutiny because it involved a fundamental right, the right to marry. And notably, for the Equal Protections Clause of the 14th Amendment, by separating same-sex versus opposite-sex individuals who are married or to be married, it creates they created an irrational classification on the basis of sexual orientation. So please read Perry versus Schwarzenegger again as part of your discussion. You'll see how this case in the Northern District of California mirrors what was to be decided in the Obergefell ultimate case decided by the U.S. Supreme Court that ultimately banned all same-sex marriage restrictions. Okay, so we're going to go into just briefly the different types of marriages. A covenant marriage is a form of ceremonial marriage that is entered upon proof of marital counseling and a promise to seek marital counseling when needed during the marriage, and that is dissolved upon separation for a designated period of or upon proof of marital fault. So the only states that offer covenant marriage are Louisiana, Arkansas, and Arizona. Their reasoning behind this is because of such a high rate of divorce, they felt that there should be an option for couples to two levels of marriage: your regular, traditional, conventional marriage, or a covenant marriage. Covenant marriage, as you can see based on this definition, has stricter requirements before getting married, so premarital counseling and a promise to seek premarital counseling when needed during the marriage, and also before just rubber stamping on divorce right away, they agree to seek counseling, and there are stricter requirements before they do divorce. So they would have to have proof of marital fault, such as adultery, or they would have to be living apart without reconciliation for a lengthier amount of time than would be required for divorce. So those individuals living in Louisiana, Arkansas, and Arizona, again, are not forced to enter covenant marriages. They just have the option of entering into conventional, regular marriages or covenant marriages. So I'm curious to know what your opinions are on this. Just something to think about. Do you agree that there should be two tiers of marriage that are offered in your state? And do you think that covenant marriages will be successful in decreasing divorce rates? Next, we're going to move on to common law marriage requirements. So in California, common law marriages are not acknowledged. But it's important to know what they are in case you have a client who comes from a state in which they were in a common law marriage, or if it just comes up. It's important to know what they are, how one is able to enter a common law marriage. So in order to enter a common law marriage, to be in a common law marriage, the parties must have the capacity to marry. They must have the present intent to marry. So, to go back to capacity, we're going to go over this more as essential requirements for annulment, but capacity generally means they must be of the correct age, the minimum age, and they can't be already married to somebody else. So capacity refers to the legal power to do something. They must have the present intent to marry, so they must intend to be married as of now. They can't say, I want to enter this common law marriage with you 6 months from now. That would not be suffice for that element. They have to agree to marry. They have to live together as husband and wife, and they must hold themselves out as married. So this holding out requirement, I think I briefly touched on earlier. They can't just say, okay, when we're inside of our home or in the privacy of wherever on vacation, we're going to hold ourselves out as married. No, they have to consistently hold themselves out as a married couple to their friends, to their workplace, at all times. So we went over conflict of laws and the validity of marriage just a few slides back. So again, to reiterate, the validity of a marriage is determined by the law of the state in which the marriage was entered or contracted, unless to do so would violate a strong public policy of the state asked to recognize it. So two really good examples. Bill and Pat live in state X, where common law marriages are legal. They enter such a marriage. Then they move to state Y, where common law marriages have been abolished. They could have entered a ceremonial marriage in state Y, but they didn't do so because they knew that their marriage was already valid in state X as a common law marriage. Bill is injured on the job and dies in state Y. Pat claims workers' comp benefits as the wife of Bill. Will state Y recognize Pat as married to Bill? Yes, state Y will recognize as valid the marriage of Bill and Pat that was entered in state X, unless, for whatever reason, state Y determines that recognizing common law marriages violates their strong public policy of their state. Now, what about case 2? Ed and Mary are both 14 years old, living in state A. 14 is the minimum age to marry in state A. They enter a valid ceremonial marriage in state A. Then they move to state B, where the minimum age to marry is 16. They tried to marry in state B, but their marriage would not have been valid. Ed is injured on the job and dies in state B. He's 15 at the time of death. Mary claims workers' comp benefits as the wife of Ed. Will state B recognize Mary as married to Ed? Now, not all states will agree on whether to recognize a marriage where the parties in which the parties were of age in the state where they entered the marriage, but would not be of age had they entered it in a domiciliary state. So some states would consider it against their strong public policy to recognize such marriages. So again, it depends on whether or not recognizing that marriage would be in violation of that state's public policy. So it really boils down to the public policy of the state being asked to recognize it. Okay, what is a putative spouse? California recognizes putative spouses. I have the Civil Code section as part of your modules. A putative spouse is a person who believes in good faith that he or she entered and cohabited in a valid marriage, even though an impediment made the marriage invalid. The marriage with such a spouse is called a putative marriage. Some states, such as California, will treat unmarried parties as putative spouses for purposes of providing limited rights, such as the right to receive support and the right to inherit from the other putative spouse. So an example of a putative marriage is a woman who goes through a marriage ceremony in good faith and doesn't find out until after her quote-unquote husband, who she believed was her husband, dies, that he never even tried to obtain a divorce from his first wife, who's still alive. In California, such a woman would be given protection. Basically, she would be awarded the reasonable value of services she rendered or a share of the property the parties accumulated during the relationship. Note that only the wife in this situation, or the woman, the innocent party, can benefit from a putative marriage. If the woman had died in our first example, her bigamist husband, or the husband who never tried to get a divorce from his first wife, couldn't claim benefits as her putative spouse. Putative spouses can collect Social Security as a widow or widower of his or her deceased putative spouse if the applicant for benefits in good faith went through a marriage ceremony that resulted in a purported marriage, but for a legal impediment not known to the applicant at the time of such ceremony would have been a valid marriage. So it's important to know, as part of this definition, they have to believe, the requirement is belief in good faith. Now, good faith is measured by a subjective standard. The test is whether the innocent party actually believed that the marriage was valid. It's not whether a reasonable person would have believed it was valid, which is an objective standard. It's based on the subjective standard of whether or not that innocent party really believed the marriage was valid. So this, basing it on a subjective standard, arguably really helps out the innocent party in this case. Finally, we're here at marriage by estoppel. Marriage by estoppel is a relationship that is recognized as a marriage because a party is prevented from asserting the invalidity of the marriage, even though grounds for its invalidity may exist. So, for example, assume that a couple lives together for an extended period but never had a ceremonial marriage, never held themselves out as husband and wife, and never had a good faith belief that they were married. After years of being together, one of them dies. Do they have survivor rights? Few states will recognize de facto marriages. So, for example, if one of the cohabitants or one of the partners dies on the job, the surviving partner might be given workers' comp benefits as the spouse of the deceased. But most states won't recognize de facto marriages and won't grant marital benefits to cohabitants in such relationships. Can you guess why that is? Think back to the Marvin and Marvin case that we discussed last week, and whether or not parties in this situation could obtain benefits under those theories. In California, yes, they would be able to. Perhaps not, not through common law, since common law marriages, since we don't, in California, we don't recognize those. And arguably, an extension of common law is a de facto marriage. So California is not likely to recognize those either. But that's when we then turn to Marvin and Marvin to see what rights, palimony rights, cohabitants in a cohabitation agreement are entitled to. Because remember, cohabitation agreements can be express or implied. Oh, sorry, I realized I was on the wrong slide that entire time. So I was talking about de facto marriages. Um, Marriage by estoppel, on the other hand, um, is a relationship that's recognized by a marriage because a party is prevented from asserting the invalidity of the marriage, even though grounds for its invalidity may exist. So, for example, Ted is married to Alice. Ted goes to another state and obtains an invalid divorce from Alice. Ted then marries Helen. Some years later, Helen files a divorce action against Ted seeking alimony and attorney's fees. Ted's defense is that he was never legally married to Helen because his marriage to Alice was not terminated by a valid divorce. Based on these facts, Ted will not be allowed to raise his defense because he's the one who procured the divorce that was invalid, the quote unquote divorce. He won't be allowed to take inconsistent positions here. So, because Ted took advantage of the divorce, quote unquote, to Alice by marrying Helen, it's unfair to let him try and do that. So, the marriage to Helen would be treated as valid because there's technically no one who can challenge its validity. The marriage to Helen thus becomes a marriage by estoppel. So, a de facto marriage, which I was talking about in reference to common law marriages in California, is a marriage in fact. It's a relationship of a cohabiting couple that is recognized as a marriage for limited purposes, even though the relationship does not meet the requirements of a ceremonial, common law, or putative marriage, although the couple has acted in a marriage-like manner. So, as it relates to de facto marriages, California will consider palimony rights to people who are not in ceremonial, common law, or putative marriages, but are in perhaps cohabitation agreements, whether that be express or implied, as a way to obtain survivor benefits and rights. Okay, that is a lot of information for this chapter. Look forward to reading your discussions on domestic partnerships in California. Also, any comments you might have, just thoughts in regards to breaking off the engagements, this long and windy road to where we're at today in regard to same-sex marriage. There's a lot to think about for this chapter. So starting with next week, we're going to get into grounds for annulment and looking at the essential requirements for marriage and what happens when you don't meet those requirements. Okay, thanks for listening. Bye.